From the Sunshine State, this is Tampa Bay's Tan Talk.
It's time for FLALAW, brought to you by the personal injury attorneys of Perenich Caulfield Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. This is FLALAW live on the radio. Thank you for joining us. As you know, we are here every Tuesday at 5 o'clock, getting ready to bring you your live legal call-in talk show. Hopefully you guys are all faithful listeners. But if not, if this is your first time tuning in, please share. Let people know that FLALAW is live on the radio. Again, this is a live legal call-in talk show. It's your opportunity to call in for the next hour until 6 o'clock to have your legal questions answered live over the air. As our intro mentioned, we are the personal injury attorneys at Perenich Caulfield Avril Noyes, and the firm has been around since 1955. We are celebrating our 70th anniversary this year, and we host this show weekly and as an opportunity to give back to our community and allow folks to be able to ask their legal questions on the air and get answers to those questions, and also just to learn and be more informed about various legal matters that could impact you, your family members, or your friends, which is why I encourage you to share with folks. Let them know, turn on your radio. Obviously, we are live right now in the WTAN studios, 106.1 FM, and also AM 1340. Also, let folks know that they can also stream the show live right now. We're on Facebook and YouTube. That allows you to continue to listen throughout the day, even if you step away from your radio. And it also allows you to be able to ask questions, comment, or chime into the conversation tonight through the comment section. So if you're on Facebook or YouTube, just search the firm name, Perenich Caulfield Avril Noyes Injury Lawyers. You should see a red circle around the logo or profile picture. Click on that, and that'll take you to the studio broadcast, and you'll see myself in the studio getting ready to get the show rolling. So hopefully you can find that and ask your questions in the comment section. And we also have this show on podcast platforms. So if you don't get to listen to the whole show tonight, maybe you come in late, or you have to drop off a little early, but you wanted to continue to watch the show, have no fear. You do have ways that you can do that as well, because this show is broadcast on our podcast platforms under FLALAW on the radio. That's how you'll find it on iHeartRadio, Spotify, Apple Podcasts through your iPhone or your Apple product. That is going to be the way that you can find not only tonight's show, which will be up later, but also past shows that have aired. Again, we come every Tuesday, so this is a weekly show, and so there's a ton of prior shows on those podcasts. So if you have a commute to work and you would like some interesting legal content to absorb and become educated on the various Florida laws, then that's a great podcast for you to listen to on your commute, or when you're cleaning, or when you're at the gym working out. If that's your thing, then follow us on whatever platform you have your podcast, because we're on there with FLALAW on the radio. So for those of you who don't know, my name is Jacqlyn Bryant. I'm one of the personal injury attorneys and partners at the law firm of Perenich Caulfield Avril Noyes. And tonight you've got me to be able to get a deep dive into some personal injury talk tonight. I am certainly happy to go over a couple things that I think are important, because I've noticed there's just a lot of misconceptions in the industry about what personal injury claims are like, what to expect kind of going into them. And so this show tonight is going to be like a peek behind the scenes, or, just a peek behind the curtain, if you will, to allow you to kind of see what really goes on in these kinds of cases. And the reason why I think it's necessary, because, you could just drive down any road, just about US 19, 275, everywhere you go, you're going to see a billboard. You turn on the radio, you're going to hear a commercial. You flip on the TV, you're going to see a TV ad, and they're all personal injury lawyers. And it's like, I don't know what's what or who's who. They all kind of sound the same. And so it can give this perception of, quick, fast, easy, in a hurry. I've seen a lot of advertisings that suggest, just give us a call and you'll have a check and you'll be walking out of the door in no time. Or, you give us a call and you'll get a check direct deposited into your account. Or you're entitled to automatic $10,000. And so I think a lot of that language and commentary sends a lot of misconceptions, and people get the wrong idea about what actually goes on with a personal injury case and how it actually moves through the system, whether it's pre-suit, meaning it's not in litigation, nothing has been filed with the court yet, or after that lawsuit has been filed and now it's into litigation and it's on the docket with a judge. What happens is quite surprising to a lot of people. I think some people, they just innately know that court cases are long and drawn out and they take a long time and they understand that process. But some people, I think, have this microwave popcorn expectation when it comes to personal injury cases. And I think a lot of that has to do with the advertising. I think a lot of it is just misconceptions about the language and what people say and what these billboards suggest. And I have to often, kind of educate new clients about the process and helping them to understand what they should expect and what the time frame usually is, because surprisingly, that's usually the number one question when people, they get hurt and they have insurance companies calling them, they've got doctor's appointments lined up, they've got, to figure out how they're going to get to work, they don't have a vehicle, the things and issues are just piling up, and the number one thing they're like, oh my gosh, how long is this going to take before, things are back to normal? And so that is not a uncommon question, and it's not surprising that people want to know that because they just want to get their lives back, right? No one wants to have to go to doctor's appointments 3 times a week or more, or having to miss work because they're in pain and it's impacting their income, or having to rely on family members, friends, rental cars, Ubers, just to be able to get around, especially when you have children and you have to pick up your kids. And there's so much that goes into the disruption of life. And so I'm never really all that surprised when people are like, how long is this going to take? And so that's usually the biggest and first question that people tend to want to ask. And so before I jump into what I want to focus on, because mostly what I'm going to talk to you guys about today is after the lawsuit is filed or when it's in litigation, because I think that's where people tend to not really know what to expect. But even before that, there is a process that's called pre-suit, meaning if you are hurt or you become injured in some sort of an injury-related claim, everything does not automatically go straight to court. So typically, the lawyers that are handling the personal injury file are not immediately filing a complaint or a lawsuit in the court system. Not to say that doesn't happen, because it does happen. However, that's usually not the first step. And so what typically happens is an investigative period and a medical treatment and recovery phase. So what we typically call that is the treatment phase, where the injured person is trying to reach what's called maximum medical improvement. And so during that treatment and recovery phase, the attorneys, are investigating, building, the evidence that might be needed, determining liability, causation, looking for whatever things they might need to piece together the facts of the case while the injured party or the plaintiff is treating. And they're seeing the doctors and they're getting the testing and they're, following up with specialty referrals and physical therapy, surgeries and things like that. And so that full course typically needs to play out before a lawsuit is filed. And the reason being is because You want to have a good sense of what the damages are, and you want to have a good sense of what future medical, what future wage loss, what future pain and suffering is there. And what a lot of people don't realize is that you have to actually have a permanent injury in the state of Florida before you're even entitled to those, intangible or non-economic damages, like the things that mean so much, which are, pain and suffering and mental anguish and loss of enjoyment of life, those sorts of things. And so how do you prove a permanent injury? Typically, that's by treating for an extended period of time so that you can actually establish that, hey, my pain hasn't gone away, and I got hurt on X date, but here we are 6-7 months later, and the pain's still there, and I'm still having to go to the doctor, and I'm still having to go to therapy, I'm still having to get injections, I'm still taking medications. That is one way to prove permanency. Now, there's other ways, of course, broken bones, having, surgical procedures that require, hardware in your body, clear changes in your MRIs, like herniated disc, protruded disc. Most medical professionals, argue that those are permanent injuries. So that's how you establish permanency. So that's what's happening in that initial phase of the treatment and recovery. Then there's a negotiation phase, right? So once the injured person has reached maximum medical improvement, then it moves into demand phase, which is where your attorney is gathering the records, the out-of-pocket expenses, the liens, whatever health-related expenses there are due to the injuries, the reports and the narratives, things that your doctors have put together on your behalf, putting that together in a neat package in the way that it needs to be presented to the insurance company, and then preparing a letter basically laying out the case, laying out the liability, laying out the damages, putting forth the future, the claim for futures, and of course, putting it all together so that in a way that the insurance company understands the claim and the importance of the claim. And then you're also making a demand for a certain amount of money. A lot of times that demand is governed by the amount of the insurance limits. And so sometimes the lawyer is asking for the policy limits to be tendered. So it just depends on the case. But that phase is all going on before the lawsuit's even filed. So a lot of times, and I'm not saying in all cases, in all instances. So there might be people listening that say, well, that didn't happen to me. My lawyer filed the lawsuit on, a week 2, or there was really no treatment phase. I got my case settled in 1 month. Things like that do happen. So there's exceptions to every rule, and I'd probably be here all night if I tried to explain why that kind of thing does happen. But it does happen, where sometimes you just got to go straight into litigation. That's where it's headed. That's the best strategy for the case. Sometimes the case settles very early for various reasons. It's the best strategy. It's the best way to resolve the medical bills in an early phase, or there's a limitation in the amount of coverage that's available in it, so it settles quickly. So there's all kinds of exceptions to the rule, but generally that treatment phase, the MMI phase, the demand, the negotiations, that could be a year-long process. And we have a 2-year statute of limitations in the state of Florida now. And so while that process is going on, the attorney is now getting the evidence that he or she needs in order to be able to file a lawsuit should the negotiations not be successful. So sometimes we go through that process, we present the demand, we negotiate, and the insurance company just doesn't do the right thing. Well, what comes next? Litigation. And that's kind of what I want to focus on tonight for the most part, because a lot of people don't have a full understanding of the pieces and parts that go into the litigation and how to really appreciate that process. So we're kind of going to go a little bit behind the scenes, talk a bit about the deposition process, the mediation process, and we'll talk a little bit about trials and arbitrations and things like that. But the biggest thing to understand is that every case is going to be treated differently on a case-by-case basis. So this is kind of a general overview. And so if your case didn't go the way that I'm explaining it, or you get in a case, find yourself in that situation later, and you're like, this is not what the lady on the radio said. Everything is kind of on a case-by-case basis. So this is a general guideline of what you can expect in terms of how things go. But that pre-suit phase, before it even gets filed with a court, can sometimes take a year, and maybe longer, depending on how long the treatment lasts. I have some clients who they start out with therapy, then they go to see a specialist, and that specialist does injections, and the injections fail. And so after a while, they go back and they get a second opinion, and now they need surgery. And the surgery gets scheduled, and then there's a recovery period after the surgery. And the surgery doesn't quite do everything that it was supposed to do, and maybe it only improved 50%, and there's still a lot of pain and issues there. And then they decide, what's next, and whether there's an alternative procedure or next procedure subsequent to the first surgery. And so that process can sometimes, go on for quite a bit of time. And so that's what can dictate a lot of times the timeline on how long these cases go before they go into litigation. So with that being said, I want to dispel the myth or the rumor that it's a quick check. I got hit by somebody, I'm going to get me a check next week. That's usually not the case. And if it is the case, you're probably selling yourself short. And you probably had much more damages and much more entitlement under the law and rights under the law that you gave away very early when you do that. And not to say that it can't be done. I'm sure people have been in situations where they got in a car accident. The next day, the insurance company called up and offered them money, and they took it, and it worked out for them. That happens. Maybe you're not all that badly hurt. Didn't really go to the doctor. The offer that they made covers everything, that you felt was needed at the time. That happens. But a lot of times it doesn't, because what you'll find is right after the accident, you might be feeling okay. A couple of days later, not okay. A week down the line, not okay. Your back starts to ache more, especially when it starts to get cold. And it's getting cold outside, and now my body's hurting in different places that I didn't realize that it could. And I think it's from that car accident. I'm going to go get checked out now. Well, if you already took that check right after the accident, it's a little bit too late to now open that claim up again. Now, you might be able to treat under your own health insurance and things like that. But as far as pursuing the at-fault driver, if you already accepted a settlement very, very early on, then you're now responsible for your own treatment, your own damages, and you've kind of signed off on your case too soon. So just get that out of your mind. People think I'm hit automatically, I'm entitled to, full damages. And that's another misconception I want to make sure I clear up. Just because you're involved in an injury claim and you feel some pain at the scene, or you have aches and pains, let's say you feel dizzy, your neck hurts, your back hurts, and then the next day you feel a little bit better. You kind of manage it at home. You ice packs, over-the-counter medicine. You do some stretches and things like that, and you're managing it. But day by day, the pain is still there, but you're just taking care of yourself. You don't go to the doctor. You don't go to the urgent care. You don't get checked out at all, but you have pain. You were injured, but you never see anybody about those injuries. That is the most, the simplest way to kind of kill your claim and kind of, unfortunately, take away a lot of the rights that you might have after a car accident because you failed to go and mitigate your damages, to get the treatment that you needed, to document the actual injury that you have. Because a lot of people, they have the pain, but they don't go treat. And, there's one personal injury attorney that I remember talking to early on in my career that said, no treatment, no case. If you don't go to the doctor and you don't treat, your car could have been a total loss. Or you've just it was mashed and mangled and your back is in a lot of pain, or you're dealing with ongoing residual effects, but you never once went to treat, never once saw a doctor, then you've really kind of given away those rights. You not only will you lose your PIP benefits, which you have 14 days to use those benefits in order to be entitled to that $10,000 in medical care and wage loss benefit. Beyond that, it's going to be hard to prove any kind of injury claim without any records or treatment, without any evidence of seeing a doctor, without any documented injury aside from your own statements, because what you're saying a lot of times can be subjective and there's no objective medical evidence to back it up or support it. And there's a lot of folks that I unfortunately have to turn away when it's like, hey, I got in this car accident, my car was beat up, I'm in a lot of pain, but it happened a couple months ago and I haven't been to a doctor. Yeah, you've already kind of taken steps that have hurt you, because it's going to be hard to go back and argue injury and causation when you've let this much time pass. And the insurance company is going to say, hey, it's been 4, 5, 6 months. You never saw a doctor. You didn't go to the hospital. You didn't go to urgent care. Something else must have happened in that 6-month time frame that made it that now, 6 months later, you're just now going to the doctor. You must have had some other injury or some other problem, or it's causally related to something else, but it can't be this car accident, because if it was, you would have treated many, many months ago. And so you never want to do that. You always want to protect yourself and get the treatment that you need. Now, with that being said, let's get into the conversation for tonight, which is litigation. Depositions is probably one of the most important conversations you'll ever have about your case. And the reason why I call it a conversation, because that's essentially what it is. A deposition is when you come in, the lawsuit has been filed, each side has been served with discovery, which is basically written discovery that your attorneys have filled out, and with your assistance, obviously, answering questions that are called interrogatories. That whole written exchange back and forth of discovery that we serve them, they serve us, they get to ask questions, we get to ask questions. That's all done in writing. Those are written discovery requests. That's requests to produce interrogatories. Then comes the big main event, which is the deposition. And I'd argue it's one of the most important pretrial events that happens in litigation, because it's really the one and only opportunity the other side or opposing counsel will get to talk to you and ask you questions about your case. And aside from that, they won't really get to talk to you again until they see you in a courtroom. Now, with that being said, maybe they'll take another updated deposition at some point before the trial, but usually they talk to you one time, and that's at your deposition. And so, there's some legal minds that say, well, at a trial, the most important part of a trial is picking a jury, or the most important part of a trial is opening statements. Well, pre-trial, in my opinion, one of the most important parts of the litigation is your deposition testimony. And it's always important to really get ready for that in the proper way and prep with your lawyer for the deposition, because that is so crucial to the outcome of your case, because they're really locking in your testimony. Previously, before that, no one really had you under oath. So, there might have been some recorded statements, potentially. There could have been written testimony about what happened. Your lawyer may have crafted a version of events factually in the demand letter, but no one has taken your sworn testimony under oath. So this would be the first time that happens. And so what is a deposition? It's basically a question and answer session. It's a conversation where the defense lawyer or opposing attorney gets to sit down with you, and they spend a couple hours usually asking you questions, and they are evaluating you. They're looking at your credibility. They're trying to see if they can get admissions from you out of your testimony that they can use against you later. a lot of times when they set your deposition, they've already done their digging. They've already, gotten your medical records. They've already poked into your past. They've already gathered your priors, meaning your prior medical records. They've subpoenaed your doctors from your past. They've subpoenaed records from your past insurance claims. Yes, they do all of that. And you're like, oh my God, that happens in litigation. Yes, because when you file a lawsuit and you put your medical condition at issue, that allows them to be able to dig into the past. And so they're trying to see, what kind of person you are, what kind of history you have, what kind of claims have you made before, what kind of other traumatic injuries did you have. And so they're going to be looking at, did you go to the chiropractor before this? Or did you have therapy for that same body part before this? They're going to be asking you questions about your prior claims, because I can guarantee you they already know what your prior claims are. They're going to be asking you questions about your day-to-day life. Why? Because they've probably been surveilling you and watching you, or if they haven't already, they will be after your deposition. And so going into that is essentially what the defense lawyer is doing. They're building their case. They're asking you questions to pin down your testimony and solidify it for the record, because it is going to be under oath. So it's sworn testimony. They're evaluating you as a plaintiff. They're looking to see, are you likable? Are you credible and believable? Are you sympathetic? Are you someone that a jury would believe, someone that a jury would sympathize with, someone that a jury would want to award the damages that you're claiming? And a lot of times that does come down to how you present in your deposition. It helps them to determine whether they want to resolve this claim before trial or if they want to try the case against you. And I've had it go various ways where depositions can go really well. And my clients do a stellar job. They present themselves in an amazing fashion. They're articulate. They're smart. They can really express themselves well to explain how the injury has impacted their lives. They listen to the preparation that was given to them before the deposition, and it makes all the difference. And the defense attorney, pulls me to the side after the deposition, is like, I like your client. I think that they've been through a lot. I'm going to go back and talk to my client and see what we can do about resolving this, because, I can tell that he or she's a good person. And, I think they present very well. And that usually always pleases me, because that means, you can see that my client for who they really are. Now, and it goes it has the same effect in the opposite way, in a sense that if folks come in there and they've got a chip on their shoulder, they're upset because my case should have settled by now. I shouldn't have had to take this case to court. You guys lowballed me, and now I'm going through this process. I got to take time off from work to show up for this deposition. You're asking me hours and hours of questions that you already know the answers to, and I'd rather be anywhere but here. And you can see it all over their face, their attitude, their body language. And they just don't want to be there, and they don't come across very well. It can have the same effect in the negative, in the sense that defense lawyer walks out of the room thinking, this is a case that I want to try. I want to put them in front of a jury. I want a jury to see the way they just acted and responded to me and my questions, because if a jury sees that, then they're not likely to award the kind of damages that they're asking for. And so it's really, really important conversation to have, and to be very, very mindful of what your attorney is telling you to do. And so just to peek behind the veil, if you have a deposition and you're preparing for it, one of the things that I would absolutely suggest is, listen carefully. Always make sure that you're paying attention to the question that's being asked. A lot of people, they get nervous. They get in that room. It's, and just so you know, it's yourself, your attorney, who's also sitting right there next to you, the defense lawyer, and a court reporter. Usually that's all that's in the room. So yes, you have the opposing attorney who's representing the insurance company on the other side. And then you have a court reporter who's there, not on anybody's side. They're just there to document the conversation and take down everything that's being said word for word. And so you do have someone, advocating for you sitting right next to you, but people get very, very nervous. They start going on and just really talking too much, or guessing, trying to explain and justify things and anticipate, well, why are you asking this? And maybe combating the question that's being asked. Don't do any of that. None of those things are helpful to you or your case. I always tell people, usually the people that talk too much in their depositions are hurting themselves more than they're helping themselves. I think I used to clerk for an insurance company in their trial division when I was in law school. And I remember one of the defense lawyers said, I love a talkative plaintiff because I just let them go on. I just let them ramble. I let them talk and talk. And I'm just giving them more rope, and eventually they'll hang themselves with it. And I think he's absolutely right. Sadly, that happens because the more you say, you end up saying things that you probably shouldn't have said, things you've said it in a poor way that can be misinterpreted. And so, and nerves get the best of you and people just chit chatter. Try your best not to do that. If you find yourself in that setting, keep your answer short and sweet, concise, to the point. Don't ramble. Don't go on and on. Don't try to debate with the defense lawyer. You're not going to win. I know you're likely intelligent. I know you've, maybe even you've studied law. Who knows? But don't try to debate the defense lawyer. At the end of the day, it's not going to come across well, and it's not going to help you in any way, shape, or form, in my opinion. I think the best thing to do is listen to the question, make sure you understood the question, then answer the question as concisely as you can. And don't answer questions that you don't understand. Ask for clarification. That's okay. I always tell people that. If you don't know, I'll be the first to admit, lawyers, we ask bad questions sometimes. It makes sense in our brain when we're saying it, but when you hear it, you're like, what in the world? What are you talking about? That's okay. Ask for it to be rephrased. Ask for it to be repeated. And do that as many times as you need to until you understand it. Because I can guarantee you, if you answer a question that you don't understand, it's going to likely come back to bite you. So try your best to never do the guessing game or trying to I think I understand what that is. And I've had so many clients who have misunderstood what a word meant, misunderstood how a question was phrased, and I knew that they were misunderstanding the question. So I had to later go back at the end when it was my turn to do the cross-examination to go back and fix that misunderstanding. Because I can't interrupt during direct if I know my client is misspeaking or testifying incorrectly or just completely misunderstanding. I can make certain objections to the form of the question on the record, but I can't, interject and answer the question for my client or correct my client and tell them, oh, no, you didn't understand that right. You need to rephrase it. I can't do that. That's coaching, and you can't do that during a deposition. So what the lawyer has to do is wait until the defense lawyer has asked all their questions, and then at the end, go back and correct the mistakes. So I always tell my clients a lot of times, if you hear me asking questions at the end of the deposition, it's because I'm trying to fix something that went wrong. Usually I don't ask many questions, if at all, at the end of the deposition because I don't necessarily think that's the best setting to do that. However, if there's been a glaring error or a mistake that has come out because my client just didn't understand, or clearly there was a poor question that was asked by the defense lawyer and it kind of twisted the conversation, or the testimony was misstated, because a lot of times the defense lawyer will go off on this line of questioning that really never even came up, or it was a misstatement of the facts that were said. And so they're mischaracterizing the testimony, but they'll go off on that whole tangent of questions. And it's like that they didn't even say that. And so I'm making those objections. And then at the end, I have to kind of go back and fix it because wouldn't you know, defense lawyers will then take that whole misinterpretation and mischaracterization of the testimony, and then they'll cherry pick that and they'll pull it out of the transcript later on and try to use it later in emotion or at mediation or try to use that as some sort of admission regarding the facts when it was really completely misinterpreted and a misuse of what the client was actually trying to say. So there are opportunities that your attorney can come back at the end and try to help you, but typically speaking, it's all you. You're the one that has to give your responses. The lawyer is not going to be there speaking for you. They're not asking the lawyer's testimony. They're asking for your testimony. So the best advice I can give you is, keep it short and sweet. The truth never changes. Always be honest in regards to your responses, and be honest with your attorney. Tell your lawyer the truth before your deposition. Because I can guarantee you, if you've got a good lawyer, they're going to be asking you a lot of the questions that are going to come up in your deposition anyway. And that's a good preparation. If you're preparing with your attorney, then your attorney's a lot of times going to sit down with you and ask you a lot of the hard questions before you even get into the room with the defense lawyer. That way your lawyer already knows what your answer is going to be before you get in that room. No lawyer likes to be surprised at the deposition, hearing things for the first time under oath, and that is a situation where, oh, I didn't know that was the case, or I had never heard that before. Don't put your lawyer in that position if you can avoid it. Tell your lawyer everything they need to know up front, good, bad, or ugly. I always say that it's easier to play offense than defense. You don't want to be defending. Make sure your attorney knows, because a lot of times what you might think your attorney, has an issue with, or you'd rather conceal that issue or maybe not bring it up because you think if you don't bring it up, it won't come up. That's not true. That's not a good way to think about it, because a lot of times it will come up. It will be found. It will be uncovered. And what will happen is, depending on how you testified, it may look as though you weren't being honest or candid about that. So the best thing you can do, if there's something that you know that's out there, even if it was a long time ago, prior car accident, prior treatment, prior disability ratings, prior whatever, if you know that it directly pertains to some of the issues in this case, and you think it could come up, or you think it could be relevant, even if you're not sure if it's relevant, tell your attorney beforehand. That way, your attorney knows how to address it. Your attorney knows how to deal with those facts before you sit down and get sworn in under oath for your deposition. So the best advice I can give you is to be honest, tell the truth, and share everything with your attorney beforehand, because your credibility is certainly being evaluated at that testimony. And if you misspeak or you forget, that's okay. But just make sure you're saying that on the record. You can fix testimony on the record. You can go back and correct something that you think you said wrong on the record. You can change your answers as long as you're still on the record. And you can do it afterwards, but I'll get to that in a minute. But those are the kinds of things that you should expect when it comes to your deposition. I mean, it's not about arguing with the other side. It's not about trying to sell your case. Let your lawyer do that part of the job. You're not there to try to sell yourself or defend yourself or fight with the other side. That's your lawyer's job. All you're there to do is to be honest, listen to the questions, listen carefully, answer them concisely as you can, and don't be combative. Have a pretty not stoic, but just a calm demeanor, so that you're not huffing and puffing and showing your agitation, which, trust me, I know it can be agitating to sit through a deposition for several hours, and you're answering kind of these menial questions like, what does this even have to do with anything? Why are they asking me this? I get it. I understand the frustration 100%, but don't let it show. I tell people all the time, keep the poker face. That's going to benefit you the most when you're going through a deposition, is to not let those emotions show, be kind, be your normal, polite self. Even if you hate the defense lawyer's guts or you can't stand the insurance company because of how they treated you, don't let it show, because again, you're being evaluated during that process. And so you want to make sure you're putting your best foot forward during the deposition. And so to go back to what I said before, it's always best to make changes and corrections on the record while everybody's still there, while the court reporter is still typing, because it gets put into the transcript, and then it also gives the defense lawyer and everybody an opportunity to address it and maybe ask any follow-up questions. So I always tell people, it's okay if you said, you know what, an hour ago you asked me whether or not it was my right shoulder that was giving me pain, and I think I said left, but I should have said right. Go back and change it. It's okay. As long as we're all still there and everybody's still on the record, fix your answers if you notice mistakes. That's okay to do. Now, what happens if you made a mistake and you didn't fix it? The deposition is now over and everybody's gone home. There is still a mechanism within the Civil Rules of Procedure that does allow you to change it, and it's an errata sheet, which is basically this document that is attached to the transcript later after you've had an opportunity to read your deposition. I always have my clients read their deposition transcript. With that being said, it'll be typed up into a booklet format. Nowadays, it's usually an electronic PDF, and you get to read the entire testimony that you gave. And it'll be line numbers, there'll be page numbers, and you can actually go through and look for those kinds of things. Did I make a mistake? Did I misstate something? Or did I misunderstand the question? And now I realize that when I went back and read it, that I didn't answer that correctly. You do have an opportunity to make those changes. So it's not as common, but a lot of times those things can be fixed, and it can be corrected on that errata sheet. So basically you would take the page number and the line number where you see the error or the mistake, and you write out what the answer should be, and then you indicate the page and line number of where it's located. And so that's how you would essentially fix any errors that were made when you were giving that sworn testimony. Now, what's the downside to that? That can sometimes, depending on the changes that you made, open the door for you having to be redeposed, meaning you have to come back and potentially answer questions regarding that particular issue that you changed. So it doesn't mean they get to come back and ask you all the questions over again, and they get a second shot at everything that they forgot to ask you, and they can come back and ask more questions. It would be limited to the change that was made and any questions that flow from that. But it could open that door. So that's why it's always important to make sure that you are very meticulous about trying to be accurate with your responses. And then if you don't know, you don't know. I don't know. I don't recall. I'm not sure. I can't remember. All perfectly fine answers when you're in a deposition. Perfectly fine things to say in a deposition. It's usually better to say, I don't remember, than to say you do remember, you give an answer, you guess, and you gave the wrong information. That can hurt you more with guessing than just saying, I don't recall. I don't recall is perfectly fine to say. And so that is kind of depositions in a nutshell. Very, very important part of the pretrial process. Depositions can be used against you in various ways, motions for summary judgment and different things like that. And so that's why I think it's a very, very important part of the litigation that a lot of people don't quite understand. And so in our last few minutes here, I'm going to go over mediation. It is also another necessary step in the litigation process, assuming the case doesn't resolve before then, because it can. A lot of people don't necessarily realize that just because you file a lawsuit doesn't mean you have to go through all the things, right? You can see it happen in various ways. As soon as the lawsuit's filed, the defense lawyer can pick up the phone and negotiate, and a settlement can be reached before you even do any discovery. Or most cases, they want to at least meet you first and do that deposition and take your testimony like I was just telling you about. And then after that, like I said, they'll pull you to the side and say, hey, I'm going to go back and talk to my client. Is there a number that could work to get this case resolved? And then the case settles and you never have to go to a mediation. And so at any point, the case can resolve. But most times they do go to mediation if a lawsuit is filed. And that would typically be the next thing or event in litigation that you have to attend after your deposition. So, we talked about the written discovery in the beginning of the lawsuit. We talked about the deposition. And then, so what's next? Mediation. So what happens at mediation? The good news is you don't have to give any testimony. So you're not going to go back and have somebody questioning you, asking you questions under oath. Nobody's going to be swearing you in. That does not happen at mediation. In fact, mediation is confidential. So there's not going to be any transcripts of what happens during this meeting or conference, if you will. It does not involve a judge. So a judge is not going to be there making rulings or deciding on anything. There's no arbitrator, so there's not going to be any arbitration award or anything coming out of that. A mediation is simply this. It's you and your attorney. It's the insurance company representative and their attorney. Sometimes it's also the defendant who is being sued. A lot of times that person is excused from mediation, but sometimes they do attend. And then there's a mediator. And the mediator is kind of like there's this neutral go-between who's bridging the gap between the two sides. And their job is to listen to the facts. They're usually very experienced attorneys or retired judges who are listening to the facts, and they're trying to help each side reach a resolution. And so a lot of people go into that thinking, what's this process going to be like? It's a couple hours. And nowadays they're mostly done through Zoom. I love depositions through Zoom, but I'm actually more a fan of in-person mediations. I prefer in-person mediations, but since COVID, they're mostly through Zoom. And so you're not in the room with anybody really anymore. But what it used to be is everybody would be sitting in the room together. Now everybody's on the Zoom camera. And there's opening statements, and then there's a private caucus, meaning you separate after the opening statements. And that's when the negotiations, the offers, the counter offers, the back and forth begins. But when that process is happening, you're not all in the room together. And so some people, they're getting nervous about mediation because they think that there's going to be this mudslinging across the table and everybody's mad with each other and you're yelling and you're pointing fingers and we're all sitting in this room together trying to come up with an agreement. Does not happen that way. The only thing that happens where we're all together is the opening statements. And lucky for the injured person, the plaintiff, they don't have to say a word during the opening statement. Isn't that amazing? They have the trust and the competence of their attorney that they hired who handles that part for them. And so it is the opportunity for the attorney to lay out the facts, to lay out the case, to give a preview of coming attractions, if you will. And you'll hear your attorney give a top to bottom of liability, damages, causation, impact, how it's affecting you in your life, how this all happened, the doctors you've seen, the bills you've incurred, the out-of-pocket expenses, the liens, everything that's due and owing, and then you'll get a full picture, and you generally will agree with everything your lawyer had to say. And then the defense attorney will get up and do their part, and I don't want to say get up. Everybody's usually seated, so it's not like a formal thing where people are standing at podiums. That doesn't happen. But the defense lawyer will do their part, and they'll do the same thing from their own perspective, from the perspective of the other party, the defendant, the at-fault driver, or however you see it. And they will say a lot of things that you don't agree with, and they will say things that may be offensive. They may bring up things about your past claims or past medical. They may bring in video or surveillance of you doing things and as an effort to show you why they feel that this claim shouldn't be paid at the value or the rate that you believe it should. They may bring in experts that they've hired and bring in their reports and say that we sent your records to our expert, and our expert says that you're completely fine and that there's nothing, there's no real findings on your MRIs, or it's all arthritis, or there's nothing new compared to the previous accident you had. And so you'll hear those kinds of things. And a lot of times I can feel my clients' blood boiling, but if they're listening to me, then they don't react. You listen. You're entitled to take notes, and you just pay attention, because it's very informative to what you're going to see at trial. And so I always tell my clients that it's a great opportunity to understand what's coming down the pipeline. Like I said before, it's a preview of coming attractions. And so it's good to understand what they see, how they see the case, what their perspective is, what their theory as far as defending the case is, and how they're, going to present their defense. And so that defense opening to me is usually where I'm writing the most notes. I'm writing feverishly during the mediation, because it gives me insight for the first time a lot of the times into how the defense lawyer is going to defend this case. And so I encourage my clients to do the same thing. Take notes, listen, pay attention to what they're saying. And when they're done, they leave the room, and you'll never see them again until, trial, if the case doesn't settle. Most times, like I said, every now and then they may do an updated deposition before trial, but usually you won't see them again. And with that being said, once they leave the room, you can then, say what you need to say, clear up what needs to be cleared up, give your attorney the rundown, and even speak freely to the mediator. That's a good thing about mediations, that it is confidential. And so you can tell the mediator, hey, they got that part wrong. They said this about my history, but I've never been to, a chiropractor before a day in my life. And they said that I had this, that, and the other. Or they told me that they said they had this and these things are false, or this is the explanation for that. And so that way you can give the mediator a better idea of what the actual facts are. Once that happens, again, you're separated. So you'll be with your attorney, they'll be with their attorney, and the mediator is the only one that goes back and forth. And the mediator's job at that point is to really try to see where the numbers are, and can the numbers be brought closer together. And usually that involves the plaintiff or the injured party coming down some, and the defense lawyer coming up some. And as that happens, you close the gap between what's being demanded and what's being offered. And if the gap gets close enough, the case can settle. If it doesn't, you walk away and you continue on towards trial. And so that's essentially what happens at a mediation. It is a negotiation process where facts are exchanged between the both sides. And, there's a bit of, opening arguments, if you will. And then, that's essentially in a nutshell. And then 90% of cases do settle, at mediation or before mediation. Only, I'd say roughly about 10% of cases actually end up going to trial. And so even if you walk from the mediation, you say, what, that offer wasn't good enough, I'm not ready to accept that. You file a notice for trial and you get a trial date set, your case can still settle even before you walk in a courtroom. So I always tell people, though, take the mediation process seriously, be patient, and understand that it's an opportunity that everybody's in the same room together to get it done. So hopefully this has been informative. You learned something about depositions and mediations that you didn't know before, because if not, then I didn't do a good job. So hopefully that was insightful. At the end of the day, we'll be back next Tuesday, 5 o'clock with FLA Law live on the radio. We'll see you next week, folks.